Thank you so much, Alicia. Good morning, everyone. I also have on the line with me this morning, Melissa Stone-Myers, who has been a participating attorney with Texas Legal since 2014. Over the next hour, we will do a quick overview on the benefits available with Texas Legal, such as estate planning. And then we will pass it along to Melissa, who will go over what you need to know about estate planning. In the chat handout section of your webinar control panel, we will be attaching frequently asked questions, our Experian flyer, Balance Financial, the summary of benefits for the select and the preferred plan, and the group flyer with rates and benefits. If you have any questions during the presentation, we ask you write them down in the chat section as well. We will be going over all the questions at the end of the presentation so that we have enough time to go through all the information. If you have specific questions about your own policy, you may also reach out to our member services team via phone or email. This webinar will be recorded and I will send it over to Alicia once it is ready. Let's go ahead and get started. So who is Texas Legal? We're a nonprofit founded in 1972, built by the lawyers of Texas to help Texans. We were created by the State Bar of Texas. We have an extensive attorney network. We're the most comprehensive plan on the market, and we're a local provider of superior service. Our mission is to provide comprehensive, simple, affordable solutions with unmatched service to protect all Texans from legal risk and its financial implications in everyday life. So one of the problems you may encounter is everyone needs legal help, but not everyone can afford to access it. Legal issues are common. In the last 2 years, 66% of people experienced at least one legal problem in the United States. Legal help is expensive. An average lawyer charges $280 an hour. Only about a third of the people who had a legal problem were able to access a lawyer. So your solution would be to purchase Texas Legal. It's similar to health insurance, except there are no copays or deductibles. Participating attorneys bill Texas Legal directly for your covered legal services. Some of our benefits are adoption, identity theft, criminal defense, prenuptial agreements, and consumer warranty enforcement. Let's talk about our legal network. Texas Legal offers a wide selection of attorneys in every area of law. We have over 400 attorneys statewide. Members choose their own attorney. Their average experience is over 20 years. They're all required to be licensed in the state of Texas. And if you don't have an attorney in your area, you can use your out-of-network benefit. Texas Legal provides protection and peace of mind for every stage of life: divorce, bankruptcy, writing a will, custody, DUI, and identity theft. We offer identity theft monitoring and protection through Experian. You will receive an Experian credit report at sign-up, credit monitoring, internet surveillance, identity restoration, and a $1 million identity theft insurance. It is available to the named policy member and all the dependents on your policy. There is a separate enrollment required. You will receive those instructions in your member welcome packet that you receive in regular mail. And you also receive these instructions in your member confirmation email once your application has been processed. It's really important for you to do this because we don't have your personal information such as your Social Security, driver's license, credit card numbers. So we encourage you to make sure you enroll. Another one of our Texas Legal benefits is the Legal Access Line. It's a telephone-based general legal advice for quick legal questions, such as, how do I apply for Social Security? How do I file for child support or HOA disputes? It is unlimited phone calls available Monday through Friday from 8 a.m. to 6:30 p.m. You must be insured with Texas Legal to use the Legal Access Line. This service only provides general guidance and is not intended for individual legal representation. Another one of our benefits are consultations. Members may seek legal advice regarding a legal issue to assess whether the participating attorney is agreeable and satisfactory for the establishment of an attorney-client relationship. Texas Legal pays for the attorney's billable time. Consultations are available via phone, Zoom, and in person. Please have your documents and questions ready for your attorney. Consultations are limited to one consultation per participating attorney per legal matter within a 60-day period. All incidental fees are the member's responsibility. Texas Legal Benefit Estate Planning, the last gift you give to your loved ones. Texas Legal pays for the attorney's billable time on your behalf, which includes a simple will or up to 8 hours for a will with a living trust, 2 power of attorneys, 1 living will, and 3 additional documents. All incidental fees are the member's responsibility. So you have 2 plans to pick from, the Select and the Preferred plan. The Select has minimal coverage, but it will cover the estate planning package. It is $10 a month for yourself or $15 a month for your family, or you can pay annually, which gives you a little savings. It's $100 for the whole year just for yourself, or $150 for your family for the whole year. Now, our preferred plan is our robust plan, and that's the one I encourage everyone to purchase. That's $20 a month for yourself, $30 a month for your family, or you can pay annually and receive a little savings. So that's $195 for the whole year for yourself, or $290 for the whole year for yourself. So how do you sign up? You can actually enroll with us at any time. You can go to our website at texaslegal.org/join. You'll want to select My Employer and provide your employer's name so you receive the group discount. You will receive a member welcome packet by mail within 2 weeks, and you also receive a confirmation email once your application has been processed. All applications received by the 25th of any month are effective the 1st of the following month. If you have any questions, we have a dedicated member services team available at 1-800-252-9346, or you can email members@texaslegal.org or visit our website at www.texaslegal.org. We have an online member portal now available. You can access your online member portal by visiting portal.texaslegal.org. Once registered, you will be able to access your policy documents, request a new ID card, and send us a secure email. You'll also receive these instructions when you enroll in your confirmation email and in your member welcome packet. I'm going to go through some frequently asked questions as well, and I'll be attaching those to the chat box shortly. You can, so how do I find a participating attorney? Visit our website at texaslegal.org. Click on the Attorney Finder link at the top right-hand corner. Load your criteria in the quick search box and click search. All your attorneys will populate. Please identify yourself as a Texas Legal member and be ready to provide your subscriber ID when making your appointment. It's really important that you let your attorney know that you are insured with us, because if they have no idea, they're going to bill you directly since they don't know to submit a claim to us. When can I use the plan? Everyone is effective the 1st of the month, and all benefits are available except for bankruptcy, which has a 3-month waiting period. The family law benefit, such as the divorce, modification, enforcement, and establishment of an existing order, has a 6-month waiting period, and it's only available to the named participant. Pre-existing matters are not covered, but are eligible for a 25% discount as long as it is not an excluded matter. Does my spouse need to be on my policy to have their will drafted? Yes, your family needs to be insured in order to use any benefits. We have a joint estate planning benefit for married couples. Just like health insurance, if you do not add them to your policy, they have no benefits. Can I add my parents to the policy? No, a family policy is considered your spouse and any dependent children, stepchildren up to the age of 26. Anyone can purchase our independent policy. What fees am I responsible for? You will have to pay the attorney for all incidental costs such as copying, faxing, postage, notarization, filing fees, court costs, etc. We suggest you discuss this with your attorney. How often can I use the plan? Each benefit is available once per plan year, and your plan year is September through August. Everyone on your policy is sharing all the benefits. Can I keep the plan if I retire? Yes, the plan is portable. You have the option of staying under your group, Texas Real Estate Commission, or converting to an independent plan. So this is your utilization from September 2021 to now. You have a total of 20 employees enrolled as of April the 1st. And one person has used the probate benefit and 4 members have used the consultation benefit. So after today's presentation, hopefully we'll have people have their estate planning drawn. Thank you, everyone. Again, my name is Diana Ignacio. I'm your Texas Legal Account Manager. Our phone number is 1-800-252-9346. Our email is members@texaslegal.org. Website is texaslegal.org. And please follow us on Facebook. I'm going to introduce Melissa Stone-Myers to you. She's been a participating attorney since 2014. I'm going to go ahead and make her the host, so just bear with us. Oh, wait. What happened? Henry, what happened? Can you?
All right, good morning, everyone, and thank you, Diana. Hopefully everyone can hear me. My name, as Diana said, is Melissa Stone-Myers. I'm with Stone-Myers Law. I am an estate planning attorney. I'm located in Southwest Austin near Bowie High School. And as Diana mentioned, I'm a Texas legal member attorney for the last 8 years. And one of the things she said was that the average experience for attorneys that are Texas legal attorneys is 20 years. So I guess I'm a little bit over that number, but that's okay. I'm not going to age myself too much today. Again, thank you for allowing me to be here. And it's nice to be before the Texas Real Estate Commission. I'm hoping to give you some education in terms of estate planning and why you want to get a will and your plan done, which actually can be quite simple. You just have to make the first step and get started. So a little bit about me. As I mentioned, I've been an attorney for many years. I've moved around a little bit. In '95, I graduated college with a degree in biochemistry. I wanted to pursue an area of the law called intellectual property, and I started out in law school at Boston University. Took the bar there, passed it, and eventually ended up moving to Pennsylvania and started working for a firm in Delaware. On the East Coast, you can live in one state and work in another. It's a weird thing, but something that it's a little hard for Texans to understand, but the East Coast, lots of little states will fit in the state of Texas. In any case, I started working in the field of intellectual property and enjoyed that. Our family started growing, and we ended up moving to Texas in 2006. And I continued working for my former law firm, but as our family grew, and I began to feel a little bit nervous once I started getting on an airplane or taking trips with my husband. We always worried about what's going to happen to our children if something happens to us, and none of our family lived nearby. Well, one of the great pieces of advice I've always been given is, rather than worry about something, see what you can do to make a plan. And it doesn't necessarily take away the things that could happen, but at least if you've created a plan, you can address the possible issues. Over the years in the different states in which I took bar exams and was licensed, one of the themes that kept coming up was wills and estate planning. And so I began thinking, I'm practicing in this one area of law that's in the area of science, but it's not really forward facing for clients, and working with this planning that I'm talking about. So I decided in 2013, I was going to go ahead and get licensed here in Texas. I took the Texas bar and I passed it. And in 2014, I started my firm here today, which is Stone Myers Law. And as Diana mentioned, I've been a Texas legal attorney for the last 8 years. I think there's some background going on. Anyway, excuse me. So for the last 8 years, I've been practicing, and our clients are generally referral based. And one of the things that I ask my clients that will come in for an appointment, the very first thing I ask them is, what brought you here, and what was your impetus for starting a will? And truly 50% of the clients have never, it matches the statistics that 1 in 2 people have never done a will. So my goal is to try to change that number. I would love to make a plan for everyone, right? If possible. So one of the things clients also worry about is, what do I do? How do I even prepare for an appointment? And so I think, again, preparation is the best thing you can do. So I'm going to offer some tips on that. So for preparing for an appointment with an attorney, one of the things you want to do is first make the phone call. Sometimes, like we do, you can book an appointment online. Some clients have that. Otherwise, you can just make a phone call and make the appointment. And you're going to be asking for one of 2 things. You're either going to be asking for existing documents to be reviewed, or you're going to be asking for new documents to be created. You can also ask for any information that can be filled out ahead of time. The reason you want to do this is so that the attorney can best guide you and know what it is, what goals you're trying to accomplish, right? So if you have lots of different assets, or if you have properties outside of the state of Texas, that might gear the conversation in one direction, versus if you're newly divorced or newly widowed, that will guide the conversation also in a different direction. So you want to make sure that the attorney can understand as much as possible so that they can be prepared for your call, and so that you can have very efficient discussion. Also, I just want to let you know, if you do have existing documents, there are some documents that can be amended, such as wills and trusts, but for the most part, all other documents have to be created fresh. So powers of attorney, things like that, they have to be created again, brand new. The other thing you could do for an appointment is create a list of assets. Again, because every family is different, people may have real estate, people may have oil rights, people may have stocks and bonds, people may have different investment accounts, brokerage accounts. It's good to go into the discussion with the attorney having the list of these assets, so you can talk about the best way to set up your wills or trust to best benefit your family. So I've been talking about documents. So you know what documents you actually need to have. We'll go over them. And Diana did mention a list of documents. And the good news is all the documents that Texas Legal covers in the plan are all also the same documents that I'm going to recommend that you need. So we're first going to talk about medical. There are 3 medical documents. They are all related to one another, but they do slightly different things. The first one is what's called the medical power of attorney. And that's the document that's going to allow someone else, you to designate someone else to talk to doctors on your behalf. So if you were ever in an accident and you were in the hospital and somebody needs to talk to who's in the waiting room waiting to talk to the doctors, that's your medical power of attorney. Like every other role we're going to talk about today, in an ideal world, you would have a primary person listed and 1 to 2 backups, because in the event your primary person is unavailable, you want to make sure that there's someone else that can be there to talk on your behalf. Now, it's great for us to have a medical power of attorney, but we don't want to tie their hands, meaning we want to make sure that they have full access to information. The best way to do that is to grant them a HIPAA consent, which means we are allowing whoever we appoint as our medical power of attorney to have access to our medical records, so that when they are talking to the doctors don't have to hold back information. They can actually have a full informed discussion with your medical power of attorney so that the best decisions for your care are made. I know some of this is a little detailed, so if anyone has any questions, feel free to put them in the chat. As Diana mentioned, I will try to get through the questions as best I can at the end. The last related medical piece is what's known as the living will. In Texas, it's called the Directive to Physicians or Medical Directive. And simply, this is the document that's allowing someone else to it's allowing, the medical directive is the document that's allowing you to decide whether or not you want life support administered should something ever happen and you're left with, like, you're fatal, you're incapacitated, and now the doctor has to make a choice. Does this person want life support administered or not? That's the decision being asked in the living will. So if a person has a living will, that's the document where they're saying whether or not they want the life support administered. If a person does not have a living will, what that means is someone else is going to make those decisions for them. So that's going to be left to their medical power of attorney. Okay, so let me give you an example here. So if you didn't have a medical, if you didn't have a living will, but let's say you really don't want life support administered. Okay, you want to die naturally, and that's your wish. But something happens, you're diagnosed with a fatal condition, you're incapacitated, you can't tell the doctors what you want. Well, whoever your medical power of attorney is, that's the person that's going to make the decision. Well, if they want to administer life support, it's up to them. So you see there's a conflict there. So if you have strong feelings, you are going to have to put that in writing and have a medical directive. Okay, so moving on to the financial power of attorney. This is the document that's going to allow someone else to make financial decisions for you, be able to pay bills on your behalf, talk to credit card companies on your behalf, do all the sort of business of your life decisions for you. So anything with regard to real estate, banking, taxes, finance, etc. So the power of attorney is probably one of the most important documents you can have, because you need to make sure there's someone else that can take care of things for you if you cannot. Absolutely important, absolutely vital. And again, like the others, you want to have a primary person and some backups. The next document to talk about is known as the guardianship declaration. This is the document that's going to allow someone else to make care decisions for you. So this is the person that is going to be able to make sure that you're cared for. And if you lost the ability to know right from wrong, this is the person that's going to be able to find you. Either they're going to be the person that's caring for you, or they're going to find you a place that you need to live and be cared for. So this is the person that's going to help you with all of these things. In order to get a guardianship, you actually have to go through the court process. So the person that is your purported guardian will open an application with the court, and they will get the guardianship instituted for you, so that they will be appointed for you. So that if you, for example, lost the ability to drive, you don't know, or perhaps you think that driving the wrong way on Mopac is a good idea because you don't have the capacity to understand, then the guardian is the person that is going to make sure that your license is taken away, your keys are taken away, and you are kept safe, because the goal is to make sure that there's a surrogate brain, there's someone in place that can make those decisions for you. The next document to talk about is something called the appointment for disposition of remains. And that's the document that allows someone else to carry out your wishes, whether they be burial or cremation. And these are so this document, the appointment for disposition of remains, is going to make sure whatever it is that you want is done. And again, this is another document you want to make sure you have in place, because if your wishes are cremation and your family doesn't believe in cremation, there's a conflict. So we've got to make sure we have something in writing that is aligned with our wishes, and we have someone that we know and trust that's going to carry those wishes out for us. Okay. The last thing I want to talk about are wills and trusts. And with talking about wills and trusts, this is where we are deciding whether or not, or not whether or not, but how do we go about distributing our assets upon death? So in determining that, we're putting in place the will or a trust. No matter what country we live in the world, there's some version of a will. And a will is a document where we're saying this person's in charge, and then here are the beneficiaries. So these are the people I want to inherit from me. And my executor, in Texas it's called the executor, is the person that's going to make sure everything gets done. Well, in order to do that, there's a process, and we call the process the probate process, because probate means we're going to administer the estate of the deceased. So we're going to figure out how to pay the bills and distribute the assets accordingly. What will happen is the person who's the executor will contact an attorney, a probate attorney, and together they will file an application with the court. And when they file the application with the court, what they're going to attach is the original will and the death certificate. And what happens then is you're creating a record within the court of basically the life and the death of the deceased. And so then what's going to happen, I'm sorry, I accidentally stopped sharing my screen. Excuse me for a minute. Let me try again. Sorry about that. Bumping the mouse. All right. So what happens after they create the application is they're going to have a hearing before the court. In Travis County, that's generally running about 4 to 6 weeks out, just based on timing, which is actually very quick. If you look statistically across the country, the numbers vary, and in certain states, it could take months, it could take years to get into probate. So in Texas, it's actually very efficient. So what happens at the hearing is the executor will go through testimony with the attorney and then before the judge. The whole purpose of this is to create a record of the deceased and prove to the court that the will is a valid will, right? And so the way they're going to do that is going to look at the will and then ask certain questions, including was the will ever revoked? Were there any children born or adopted after the date of the will? And certain other questions just to ascertain that the will was actually valid. Because if it's a valid will, as we suspect it to be, we're going to go ahead and be able to appoint the executor to then start administering the assets of the deceased. So short hearing, application, next step, the judge gives the executor what's known as letters testamentary. So if you ever hear that term, that basically means it's the right of the executor to then be able to tell, say, Chase Bank, yes, you will deal with me because I've been the appointed executor in this estate, or talk to the realtor and say, yes, I have the authority to sell this house. So letters testamentary, if you ever hear that word, it means if somebody's asking you for letters testamentary, it means the probate process has to happen. So if someone does die and you hear letters testamentary is needed, it means probate's needed. Okay. So just kind of that word, if you ever hear that word, that's what that means. So once the executor gets the letters testamentary, now he or she can start selling property or retitling property to whoever the beneficiaries are. So what the executor is going to do is kind of go through the inventory of what the person had when they died and start moving title off of each of those things. So if you remember a few minutes ago when I said when you meet with an attorney, you're going to be talking about perhaps all the different pieces of your plan or of your estate, meaning do you have insurance policies, do you have retirement policies, do you have oil rights, stocks and bonds, et cetera. These all will come into play when your estate is probated, because your attorney and your executor are going to need to start changing each of these things over to whoever the beneficiaries are, according to what your will says, because your will is the one that tells what happens and who gets what, correct? Now, there's something else I want you to, another term I want you to be familiar with. If you ever hear the term non-probate, yeah, the exact opposite of probate, right? So what does that mean? Well, I like to think of probate as kind of being on MOPAC, right? We're going along the process with the court with the help of the attorney. And now that we have our letters testamentary, we're able to officially change title over to each of these documents or each of these assets we have. Non-probate means you don't have to go through the court process. And the reason why is that you will have, the person who died will have during lifetime had policies such as life insurance policies, such as retirement policies, where they will have named beneficiaries. And if they did that, those policies are outside of the probate process. They're non-probate because someone, the beneficiary, can contact whoever the company is that holds that policy and say, pay me. Meaning, here's the death certificate of the person who died. I'm the named beneficiary. Here's my identification. Pay me, write me a check. Which means we do want the executor to know that these policies exist so they can at least notify the beneficiaries to get them started on claiming the policies, but we're not tasking the executor to deal with this. This is not something that's going through the probate process. Now, something else that will go through the probate process and the executor will help with is if there's any minor children. If there's minor children in your will, you will have also listed guardians for your children. And so the executor is going to help facilitate the institution of who the guardian is that you've listed in your will, right? And so whoever that is, the judge is going to meet them, talk to them, evaluate, make sure that they're still the proper guardian for your children, right? If you have a will that's 10 years old and perhaps the guardian is in ill health, that's not who the court is probably going to appoint, right? They're going to look further down the list of your alternates and see if there's someone else that's in a better position. So the executor is going to facilitate all of these things through the probate process. And then there's some other things that we're going to ask the executor to do. They need to notify all the beneficiaries, they need to notify all the creditors, and then they're going to create an inventory of the estate. One thing that is going to also be in the will is what's called a contingent trust. Think of this as a little what if provision. So we've got something in the will that can occur if something triggers it. And the trigger would be if you have, like you, the decedent, the person who died is the decedent, has any assets that are supposed to go to a minor, meaning anyone under 18, you may have the decedent in your will put together a clause that says, if I leave anything to someone that's a beneficiary under the age of 18, 21, 25, whatever age you come up with, instead of giving it to that person directly, I want it to be able to be held in trust in an account for their benefits to be held by a trustee, the person who's going to manage it. So just kind of think of that, that is the ability to set aside money for someone too young to handle it, but you've got a plan for who's going to manage that money until a child's old enough, okay? All right, so I use the term trust. Think of that as a little trust, right? Because I'm going to now distinguish big trust, big T trust. So a revocable trust, if you've heard this term before, what this means is who is the person, or not who's the person, the big T trust is you're creating a trust that is going to manage assets, your assets for you. So you're going to create it, you're going to manage your assets during your lifetime. But the beauty of it is you're spelling out the same things you would put in your will, meaning whoever you want to benefit, your beneficiaries, they'll also be listed in your trust. But instead of going through down MOPAC with the court through the probate process, you're putting all of those things in the trust so that your trustee can manage those assets, start distributing the assets according to the trust privately, not with the court. But the only way to achieve that is one, you create the trust, and two, you have to start moving your assets into the name of the trust. What do I mean by that? Remember when I said that the executor has to start going to the bank, selling the property, retitling property, moving the assets from the decedent's name to whoever the names of the beneficiaries are? Well, what you would do if you're creating A trust, a living revocable trust, is you will start, with the help of your attorney, moving real estate into the trust. Okay, so your real estate then goes into the trust. And then any of your other accounts will start getting moved into the trust, and the attorney will provide you instructions on how to do that. What does it look like? So if you have a home right now, and let's say the home is Fred and Jane Smith, instead of having the home deed say Fred and Jane Smith, a new deed would be created that will look something like Fred and Jane Smith, comma, trustees of the Smith Family Trust. That little act of moving, renaming the home and your account similarly into the name of the trust is enough to then move all of your assets one by one into the trust. And that's how you can avoid probate. So then your trust, having a trust, that mechanism becomes a non-probate. Your assets then become non-probate assets. I know that's a lot to unpack. And again, if you're thinking, do I want a will or a trust? That's something that a consultation with an attorney will help you resolve. But I want to make sure you have some familiarity with the term, because these are terms that I have clients that really get confused between, they mix up living will and will, they mix up power of attorney and will, they might call everything a will. So know that there are different pieces of an estate plan, and we're trying to introduce the topics to you. So I've talked about the different documents. Now, what happens if I don't have some of these documents? Well, for medical, if we don't have a medical power of attorney in place, then we don't have someone to serve as our advocate. In the law, our doctors are in the business of saving people. So by law, what's going to happen is they're going to start looking at, okay, we really want to help this person. We need to talk to someone. They don't have a medical power of attorney. Okay, well, do they have a spouse? Okay, great. We'll talk to their spouse. Do they have any children over the age of 18? Yes. Do they have, if not, go down the list, then parents, siblings, etc. Well, okay, well, what happens if we are an unmarried person, but we've been in a relationship with someone for 10 years, maybe we're engaged, maybe we're about to walk down the aisle next week. Guess what? That person's not blood. Okay, so that person's not going to be able to make medical decisions for you. Again, you can design around this by just creating the medical power of attorney. So Texas can create, your will can create these documents for you by default, because if you don't have them, then the law has to say who's going to speak for you. But the best way to plan is to put something in writing where you're choosing who your people are, not Texas. And I brought up life support, right? That's another thing. If you have strong feelings about whether or not you want to be administered life support, you need to have a living will in place that says that. Otherwise, it's going to be up to your family or your medical power of attorney to make that decision for you. And then finances. If you don't have a power of attorney, then the only way, there's nothing in the law that says, oh, well, then if you don't have a financial power of attorney, your spouse can act for you. Absolutely not true. If you've lost the ability to pay your bills, you don't know what's going on, you haven't remembered to pay the utilities, they're going to shut things off. The only way to solve that problem and have someone be able to have access to your checking account and start paying bills for you, or arguing with your credit card company over charges, is to have a power of attorney. If you don't have the power of attorney, then you're going to have someone institute a guardianship for you. And as I mentioned earlier, the guardianship process is a long, involved one. It costs money. There's going to have to be a physician's diagnosis that you're incapacitated. Then the court is going to appoint someone to be your guardian. Okay, so again, the way you plan around that is you have these documents in place. If you don't have a will, Texas creates one for you. I have several slides later that I'm going to try to go through different examples and scenarios, whether you're married or not, children or not, about how your property passes if you don't have a will. But know these terms from the outset. The word intestate means dying without a will. Know that if you die without a will, what your family is going to be seeking is what's called a determination of heirship, because there has to be, the court can't start distributing your assets until they know who your heirs are. Well, guess what? You might know who your heirs are, but the court doesn't. So the court is going to appoint what's called an attorney ad litem, which is a court-appointed attorney that is going to be paid by your estate to start doing their own investigation into who your heirs are. The attorney for your estate, so the applicant, the person that's going to try to figure out who your heirs are, that person is going to hire their own attorney, which guess what? That money is coming from your estate as well. And they're going to then try to prove who the heirs are. And so they're going to need witness testimony. So it's a long, drawn out process before you get to start distributing the assets. That process is going to cost probably 10 times what your will would have cost. So you really don't want to do that. You want to just go ahead and get a will done, make it easier for your beneficiaries. If you're gone, they're going to be going through grief. The last thing you want is for them to be spending money and doing additional paperwork and emotional things that they wouldn't have to otherwise. And then children, if you happen to have minor children, now the court is going to be left to figuring out who the guardian is going to be. You won't have appointed it because you didn't have a will. So you're going to want to make sure to have a will so you can have control over who your guardian is. Otherwise, the court's going to look to family members, right? Well, what if the person that you wanted to be the guardian of your children was your best friend down the street? Again, the person's not blood. That person is not going to be listed as your guardian, okay? Because they're going to start looking at people within the family to be the guardian. I'm talking to the Texas Real Estate Commission, so I want to give you 2 examples for if you own real estate and you don't have a power of attorney, and if you own real estate and you don't have a will. 2 examples of things that have happened to clients that I know that didn't have these things. So first of all, if you don't have a power of attorney and you own real estate, you absolutely should have a power of attorney because something like this could happen. True story. So I had a call from a banker, and she had a client whose spouse was in the nursing home, and her client wanted to be able to sell their house because the spouse wanted to move into something smaller, needed to access the funds for his spouse's care, but he couldn't do that because he and his spouse never created powers of attorney. They didn't have anything in writing that would allow her to give him the consent to sell the house, which is a big problem because when you own a property with someone else, like your spouse, you don't have rights over selling it unless they give you consent. And even though she probably would have given him consent, she couldn't because she didn't know what was going on. So therefore, she couldn't sign the contract to sell. She didn't give him a power of attorney. So this poor man, the only option he would have had was to get a guardianship over her. And then with the guardianship over her, then he can take control of her estate and then sell the property. And again, what did I tell you about guardianship? A physician's diagnosis for her that she's incapacitated, that takes time. Then instituting the action with the court again appoints an ad litem to be able to investigate for her. Does she really need a guardian? More money is coming out of the estate. And then there's that long process. We've got to make sure we have a guardian. So we've got to make sure everything, evidence, witnesses, et cetera, before the guardian is appointed. So if there was just a power of attorney, that real estate could have been sold. Next, if you don't have a will and you own real estate, again, another problem. So true story here, there was a family and husband and wife, they bought a piece of real estate together. Unfortunately, he died and he had children from outside the marriage. But unfortunately, he didn't have a will. And so when he died, his wife did want to sell the house because she wanted to move closer to her family, but she found out she couldn't because his name was on the house and she couldn't do anything unless his will was probated. Oh, he didn't have a will. So now what happens? That's right, determination of heirship. Sadly for her, because he didn't have a will, when the court determined who the heirs were, his half of the house, you're right, not going to like this answer. His half of the house went to his children from outside the marriage. She still keeps her half of the house, but his half went away. It went to his kids. So now she's thinking this, I'm using this money. I'm going to be able to buy a new home with my family. I just lost my husband. Well, guess what? Not the desirable result. But again, if they had just created wills, that scenario could have been avoided. Or a trust, either way, as long as there's something in place that covers the real estate. They would have been set in that situation. Another thing I want to talk about to you, Diana had sort of mentioned that you can put dependents on your Texas legal plan as long as they're, your children up to age 26. Well, think about anyone over 18 should have medical powers of attorney, durable powers of attorney. So I want to just kind of introduce this to you because know that if you have a Texas legal plan, this is something else you could utilize the plan for. In my office, I do what's called a college pack, and I do that for students who are graduating. Maybe they're not going to college, maybe they are, but once you turn 18, your parents can't talk to doctors on your behalf. Your parents can't talk to your Discover card and fix those errant charges, can't pay bills on your behalf, can't do those things. So you want to make sure you've got those proper legal documents in place for your children so that you can have that conversation with the doctors if your kids are in an accident, or you can take care of paying for the bills. So again, if you have Texas Legal and you have that family plan, this is something that you could use to benefit your children. Okay, I know we are sort of running out of time, but I'm going to try to go through some of these slides with you because I think this is very instrumental. If you don't have a will, you definitely want to get one because this is what the Texas will looks like. And this is not what most people think is going to happen. All right, so the following slides, I can't take credit for. Instead, Judge Guy Herman, he is our Travis County probate judge. He actually put these together. And when you're doing a determination of heirship that I spoke about earlier, this is one of the starting points. This is where you're going to start looking at, okay, when this person died, what category do they fit in? And then what category are their assets? That's how we'll figure out who the assets will ultimately go to. So the first slide, we're going to talk about a married person with children. If you look at the top, there is an A, it says decedent's separate personal property. Think of separate personal property as somebody's truck, somebody's tools. So the decedent, let's make our decedent Fred. So Fred had tools, he had a truck, he had some stocks and bonds, all in his name. It's all things that he owned separately. He didn't own them with his wife. He had them separate. So what's going to happen to those things is 1/3 of those assets will end up going to his spouse and 2/3 go to his children. Okay. Now let's say Fred had a valuable farm in East Texas, and he owned that with his brother. And he really had assumed he was going to pass it on to his wife, Wilma, but Fred never did a will. So guess what's going to happen? That farm, so his interest in that farm that he owns with his brother that Wilma thought she was getting isn't going to her. Instead, that farm is his interest in the farm is going to his children. And Wilma will get that 1/3 life estate, which doesn't mean ownership interest, but she can have use to it while she's still alive. Now let's talk about property, the community property. So the home that Fred and Wilma own together. If Fred and Wilma's children were only children from their marriage, she gets his half of the home. But if Fred had children from outside the marriage, like that client I mentioned to you, then his half of the home and any other community property that they had together would be going to his children. So anything that the couple owned together, if he had children from outside the marriage, his half is going to those children. Probably not the result we thought we were going to get. All right, next slide. Let's say we are dying, we die without a will in Texas and we're married, but we have no children. Okay, this is a little simpler. So if we have separate personal property, so again, think Fred has that truck, Fred has some tools, or if the community property, so Fred and Wilma own that house together. in both those scenarios, A and C, Wilma gets it all. Great, because there's no kids. But any separate real estate, so now think that farm in East Texas. It's going to depend on whether Fred had still living parents or siblings. And then depending on if he has both parents living, then each parent gets a quarter share and his Wilma gets a half share if there's, and so on. So it kind of goes on from there, depending on if you have siblings, living parents, etc. Next, let's say you're unmarried. Okay, so number 3 is the easiest one. If you're unmarried and you have no children, great. Your children, or I'm sorry, you are unmarried and you have children, then your children take everything. Easiest one. However, in order to get there, those kids are going to be going through that determination of heirship to prove that they're the only children, that there's no other, that there's no other parent involved, that their mom or dad was still married, etc. And then lastly, if you're unmarried and you have no children, then there's another scenario. So if you're unmarried, you have no children, your parents each take half. If you have siblings and only one surviving parent, then they're going to take a portion as well. So these slides, or this is also on the Travis County website. It's also on my website. So if you guys want to spend more time on it, you certainly can do that. But I just want to, looks like we're running really low on time. I want to make sure I can go through, just recap. So Texas Legal does cover all of the things that I told you need. Guess what? If you have Texas Legal, you can get all of those things done. You can utilize your plan benefit once per plan year. The cost of private paying, yes, you're going to be saving hundreds and thousands of dollars by getting this done. So not hundreds of thousands, but hundreds or thousands, depending on the attorney that you would otherwise be privately paying with, and then you'll have peace of mind. And I know that there's probably questions, so I'm going to try to go into the chat and find them, which let me go ahead and stop sharing in the chat. Let's see. I am Diana. Are you seeing questions? Not sure if anyone wants to unmute, and I'm not sure if I see any questions so far. If anyone has questions, feel free to go ahead and type one.
Okay. We don't have any questions, Melissa.
Great. Thank you. And I didn't see if I saw it, I didn't see any there, but I wasn't sure. Where should you keep the document? So, great question. So some people ask, if they should create a safe deposit box. I don't like that. I want your originals to stay with you. So keep it somewhere secure in your home. Some people have safes in their home. You don't need a safe. You can just put it in a closet. You can put it in a bedroom. Just put it somewhere that you're telling your loved ones where your originals are. And like our office creates a PDF scan of all of your originals. So it's always good practice to do that as well. And you can give copies to your whoever you're appointing, you can give copies to. Yes, that's a great question. And I'm sorry, I realized that I chewed up a lot of the time. So Diana, did you have other things you wanted to cover? I'd like to thank you for your for turning it over to me. And I'm sorry I chewed up so much of the time.
No worries, Melissa. Thank you. You did a great job. That was all very good information for us. There's another question. Do you recommend talking to your kids about the guardianship?
That is a great question, and I will try to answer that in the time left. Yes, I think it's good. It depends on the age of the kids, but we did. I mean, I now have kids that are in college, but that is something we did involve them in the process, mainly because a lot of families don't end up choosing people that are family members to be guardians. It just really depends on the family and where the family is located. But I do think getting the buy-in from your children's insightful. I think that's always a great idea if your children can handle it. And again, the older the child, the easier they are to understand. But I think really even starting as late elementary school, there's children that would have input. I'm not sure I'd be talking about it to like a 3 to 7 year old because they start thinking about, they can't really understand the concept of death that well. So I don't know that I would talk about it with them. Right. Well, if anyone, oh, looks like there's another question. Usernames and passwords to online personal accounts. Would the beneficiaries have access? Okay, so your beneficiaries probably are not going to have access, but that is something that you want to convey that information to your executor. So the best practice and something we do is we give our clients a records form, and that would be kind of where they would start writing those things down. But some people have their own organizer of keeping track of I have these accounts and these are the passwords, the logins, et cetera. So whatever your system is, you absolutely want to keep that. And I would say go ahead and keep a copy of that with all of your legal documents so that if someone is helping you, they know where to start, right? The whole goal is we're creating peace of mind for ourselves by creating a plan that we're giving as much information to our people that are going to be our powers of attorney, executors, et cetera. When you declare beneficiaries, okay, so great question. So yes, that was when I was talking about non-probate assets. So retirement accounts and insurance accounts, when they name beneficiaries, those are non-probate, which means they, if you've listed a beneficiary, that trumps all. So whatever your will says, whatever your trust says, if you've named a beneficiary in those accounts, whoever that beneficiary is the one that's going to inherit those accounts. So if you say, if Fred said, I want Wilma to get my life insurance policy, but in his will, but on the life insurance policy, he wanted it to go to Tito. Well, Tito's the one that's going to get that benefit, the money from the policy, not Wilma.
Okay.
All right, well, thank you. Thank you so much, everyone. Thanks for Real Estate Commission. I'm sorry I chewed up a little bit more of your lunch hour. If anyone has other questions, please pass them on to Diana. And Diana, I'll turn it back to you. Thank you so much.
Thank you, Melissa. That concludes our presentation for today. Thank you again for joining us. As a reminder, if you had any questions regarding your Texas legal plan, please reach out to our member services team via phone or email. Again, I will be sending the recorded link to Alicia once it is ready. Please follow us on Facebook and our website for access to past events as well as information on upcoming events. Everyone have a wonderful day. Thank you again. Bye-bye.